Hello, I'm Father Deacon Andrew Bennett, Director of the Cardus Religious Freedom Institute. On June 16th, we mark the first anniversary of the passage of Bill 21 in Quebec, known by its full title as an act respecting the laicity of the state. This law banned the wearing and outward display of religious symbols by public sector workers in Quebec, including teachers, crown prosecutors, and certain classes of civil servant. The law and its effects have not been without controversy, both inside and outside of Quebec. Indeed, there's already been one significant court challenge to the law. To explore the secular law 1 year on and to examine its legal aspects and its impact on fundamental freedoms, I'm joined today by Professor Robert Leckey, Dean of Law at McGill University. Professor Leckey is a full professor at the Faculty of Law at McGill, where he teaches constitutional law and family law. On the 1st of July 2016, he began a 5-year term as Dean of the Faculty. He's been one of the leading public critics of the secular law and its impact on fundamental freedoms. Robert, good to have you with us today.
Thanks for the invitation.
So let's start off. Just give me your take on 1 year on. We're now, we've celebrated just the other day the 1 year anniversary of the passage of the law. What are your thoughts? And maybe reflect a bit on what you were thinking a year ago and what has transpired.
I mean, a year ago, people were still sort of in shock at the process, how thin the consultations were, how few religious groups were actually invited to Quebec City. The whole thing was rammed through. There were very brief hearings in May, and then in June, there were last-minute amendments. So things were brought in, not quite at the 11th hour. We're talking hours before the thing was finally adopted by the government invoking closure. So it was sort of rammed through so people could go on their summer holiday. And the language a year ago was, we got to sort of put this secularism issue to bed so we can move on with the barbecue season in our constituencies. And a year later, it hasn't gone away. It hasn't ended the debate as we could have predicted. I think a year ago, it's had very concrete, very painful consequences in people's lives. And there's been a kind of creep where the four corners of the statute don't limit the impact of it. And so we can talk a little more about that if you like, but it sends a message that is not limited to the sort of strict categories listed in the appendix or the numbered clauses. It sends a broader message that the province is suspicious of religious minorities that are visible.
Well, it seems to be saying a strong thing about the whole national project in Quebec. And some might say that this is somehow a culmination to a debate that's been going on for decades around religion and public life and the national project coming out of the Quiet Revolution. Do you think the secular law serves as some sort of manifesto for Quebec society and its view on religion and religious freedom?
Well, Quebec is such it's a complicated place, and there are multiple views about religion. And I don't think you can trace a straight line from the Quiet Revolution to what this law is. So there was clearly a movement in the 1960s to sort of set up a provincial ministry of education to make sure that the health ministry was running health and not just religiously run hospitals. So you can see there was a kind of process, but there were the attempts to sort of make Christianity or other religions invisible. There are not very deep roots to that. And so the conception of secularism has sort of changed. And so the idea that religion is to be strictly private is not one that has very deep roots in the province. And if you track, I mean, in some ways, the Catholic majority remains still very visibly religious. Whether they're observant by being at Mass on Sunday is a different story. But the Pope dies, and it's a huge event within the province. When a big hockey player dies, the state funeral is in a basilica in downtown Montreal, and it's very religious, and everybody's there. So there are multiple stories about religion going on in Quebec all the time. And Bill 21, I mean, in a sense, the beauty of it as a political strategy was that it brought together such distinct views. It brought together people who are genuinely deep, sort of hardline secularists, and it brought those people with others who might be uncomfortable about the place of immigration in society or nervous about Muslims. Like, they all sort of come under the sort of federating umbrella of support for Bill 21.
How much of this do you think might be, getting to the point you're raising about Catholics in Quebec, how much do you think the response from those sort of, those people who are culturally Catholic in the province is really in looking at these other communities that are more deeply religious? If we speak about Hasidic Jews, if we talk about Muslims or others who are more visibly religious in the province, is there maybe a sense that amongst, maybe implicitly within the predominantly Francophone formerly Catholic population that, well, we've moved on. We have more of a cultural space now for our faith. What you're doing, other groups, is something very different, and we're not quite sure about it and whether it sort of fits in. Do you think that is a fair assessment of maybe some people's thinking? Like, we don't know how to actually engage with these other religious communities?
Obviously, again, there's multiple stories, right? So, but one thing that I think is going on is I think people associate the kind of liberation narrative that many Quebecers feel regarding the Catholic Church, and they sort of put other people's religions into that mold. So female Quebecers who grew up at a time when the Catholic Church was tightly sort of regulating families and discouraging family planning and things like that, when the sort of church and the government were closely intertwined in governing the province and in imposing a particular religiously inspired vision of morality. The sort of liberation away from that, people now associate with other minority religions. So, the idea that a school teacher might be wearing a hijab, some people look at that and imagine that that is somehow imposed on that school teacher the way that Catholic norms might have been imposed on the entire province in the past. And so, and it's obviously a different situation. For a diasporic Muslim to be wearing a religious symbol here in Quebec is not the sign that any kind of institutional religion is controlling them. And so part of the thing is finding space, I think, in the kind of narrative, in the discussions. How do you make space for the liberation story that many Quebecers experienced without reproducing it or mapping it on to a very different trajectory of other groups?
Well, I think that says something really interesting about the common good. And what is the common good that this law is trying to promote? And how does that dovetail with respect for fundamental freedoms? So what do you think is maybe the, stepping aside from the legal question for a second, what is the broader cultural goal here by taking this approach towards fundamental freedoms? What's the vision of the common good that you see embedded within this law?
I mean, the vision, and it's not separable from the legal arguments and the justifications put forward, but the idea is that the society is one in which people need to be free to make their own choices in private, rather than to have people somehow imposing their views on others. And where the conversations go wrong very quickly is the whole question of whether my wearing a religious symbol is per se me proselytizing towards you, or a teacher's wearing a hijab. Is that necessarily, is the very fact of wearing a hijab somehow imposing it on others? And we've moved in sort of dominant discussion takes the mere visibility of a symbol as necessarily impinging on other people. And so the sort of imagined public good is a space in which nobody's being proselytized against, if you like, by anybody else's religious symbols. And there's a sense in some quarters that the children in schools, for example, are themselves vulnerable to such kind of conversion efforts, that simply seeing a school teacher wearing a religious symbol is that teacher's effort to convert them. There was a big incident last fall during part of the litigation in which the Chief Justice of the province at the time asked a question to a government lawyer. And she said, you're asking me to balance some people's fundamental right to work with other people's visual allergy to seeing religious symbols. And it struck a number of people as a perfectly reasonable question. But others were horrified by the question. They thought it was biased. They thought it was a complete misunderstanding of the seriousness underlying Bill 21. But it does seem to rely on the idea that simply seeing someone else's religious observance necessarily affects the observer.
Well, it seems to speak also to this division that Charles Taylor has really emphasized between sort of a closed secularism and an open secularism. This open secular space where the state is genuinely, to be funny, agnostic about the place of religion in society, and sort of allows for a free market of religious expression within, the bounds of the law. And then you have a sort of a closed secularism where the state imposes a particular understanding of the secular space, which is not neutral. It does make certain claims. And so I think to many people, the argument that people who wear religious symbols are somehow proselytizing is rather rich when you look at the claims that seem to be made by the law in terms of the state advancing a particular secularist narrative as sort of essential to the national project.
The law itself states that it is, in a sort of curious way, the law itself states early in its text that it respects freedom of religion, respects people's equality, freedom from discrimination. All that's laid out in the law as if that's somehow compatible with the content of the law. And as you mentioned, it's a very particular conception of neutrality, because some people are able to observe their religion to the full extent that they sense their tradition calling them to do while respecting the law, and other people run against it immediately because they feel impelled to wear a religious symbol and to manifest their belief in a particular way. And so obviously the law has deeply differential impact from one faith to another.
Well, it's probably not surprising that the first challenge that came to the law was around a young woman who wears hijab, hijabi Muslim woman, a case involving the National Council of Canadian Muslims and the Canadian Civil Liberties Association. And in that ruling, Haque versus the Procureur Général du Québec, Justice Yergo denied the application for a stay of the law that was being sought by the applicants, and that was then upheld at the Quebec Court of Appeal. So I guess 1 year on, we can expect to see more of this type of litigation. My question to you is, the government is somehow unmoved by these appeals to fundamental freedoms, as it's defending this law as core to, again, the project of Quebec. So from a constitutional law perspective, how tenable do you think that position of the government is in the medium to long term as we see more and more cases come forward?
Well, I think there are very sound constitutional arguments that will be aired in court eventually. The government used what we call the notwithstanding clause in the Canadian Charter and the analogous clause in the Quebec Charter of Human Rights and Freedoms to shield the law from some of the more obvious attacks. But I think there are fundamental arguments that will have a very good shot once they get in front of the judge. So, because the Canadian Charter and the notwithstanding clause don't exhaust the fundamental principles of the Canadian Constitution. And so I think the government will have a rough time with it. I think it's aspiration that by ramming the thing through before the summer recess a year ago would somehow close the chapter. I think they'll find that's not the case at all. As time goes on, I mean, one of the objections voiced against in the very first legal proceedings a year ago was that it was hypothetical. It was too soon to know whether the law would actually ripen into harm in people's lives. Well, the litigants are certainly collecting evidence of that now. It's very plain that it has, that it is denying people employment. It is having an impact, and it's not just Muslims. So a couple of the plaintiffs named in one of the kind of sister lawsuits are Catholics who are prevented by the law from showing their faith in the way they would like to do so. If I could just give an example, I mentioned that there was a kind of creep, that the law reaches broader than its four corners, and we saw that as soon as last August. So the law includes a grandfather clause that allows someone who is currently hired, I think by the end of March of last year, to keep their job. So that means that there are teachers who can wear religious symbols, there are government lawyers, and a range of other affected employees. Well, in August, parents, in a kind of predictable way, hearing the government's message that, look, a teacher wearing a religious symbol is not neutral and is somehow a threat to the student, some of those parents started contacting the school board saying, we want to make sure our kids aren't taught by any such teachers come September. And so then you see the real tension, because Bill 21, in an effort to limit the collateral damage, has a grandfather clause, and yet it's based on a principle that someone wearing a religious symbol is harmful and is proselytizing. And so the government had to intervene and sort of say, look, we're not going to move people. You can't avoid a teacher wearing a religious symbol. And yet the government had itself opened the door to that. Relatedly, some school boards said, look, the law doesn't apply to student teachers, people who are sort of doing a stage or internship. And yet those internships are part of our hiring process. And if we're not allowed to hire someone because of their religious symbol, we would prefer to reject them at the level of the student teacher. And so you see the law being applied more broadly than its formal reach. And so this is one of those things, once you start it, it's very hard, I think, to keep it under control.
And I understand that despite the grandfather clause that exists, if a hijabi Muslim woman or a turban-wearing Sikh was then to change that job and apply for another job, let's say in the same school, maybe to become a vice principal or something, then the law kicks in.
Completely. So you couldn't switch districts because your spouse gets a move for her work or his work. You couldn't get a promotion. It's very limiting. And so the government's sort of reassurance that the grandfather clause was going to prevent harms or injustice to people doesn't pan out. And in a sort of oddly vindictive bit, the grandfather clause only applied to people who were in their jobs by March of 2019, as if everybody else should have been governing themselves accordingly from the moment the law was introduced. People shouldn't have bothered to finish teachers' college. They should have sort of taken their losses and moved on. There really seems to be a lack of compassion for those affected by the law.
Just moving on a little bit from one of the points you made earlier, over and beyond the impact that this law has on public servants, can you see it having a broader impact on Quebec society in that it maybe some would argue that it gives license to people to discriminate against people outside of the governmental sphere, to discriminate against people who wear outward religious symbols? Do you think we'll be seeing that, or is that maybe unlikely in that, that people won't sort of interpret it that way?
Well, there's a sort of, to me, that raises the question of the sort of formal discrimination and the informal discrimination. So formally, it's already kind of confusing, and even while the law was being debated, there were companies in the private sector wondering if this would somehow apply to them. So there's clearly the potential that people will just misunderstand where the law reaches. And then there's the other stuff that women's groups have already been tracking and counting and will put in front of the judge in the litigation, like the times in which women wearing a religious symbol are insulted on a bus. Those, the incidence of that has gone up. Spitting at people in the streets, shouting things at them, like that's actually measurable. The number of complaints around such conduct has gone up. And, there may not be a direct causal link that you can prove between the government and these incidents, but the government's action, I think, has affected the social environment. It's politicized the mere fact of taking the metro in Montreal and wearing a hijab, because suddenly everybody's been made to think, look, that's something that, at least in some contexts, is impermissible and frightening. So yeah, I think it does affect the whole society.
Sort of talking about sort of the constitutional dimensions of this again, the government obviously believed that by embedding the notwithstanding clause within the law, it would shield it from any degree of real sort of scrutiny in terms of fundamental freedoms. But I mean, there are other parts of the Canadian Constitution that could apply in this case. I'm sort of thinking to the Quebec Act and what it says about the rights of the sovereign's Roman Catholic subjects. You look at subsequent acts that relate to the rights of the Jewish community in Montreal that predate Confederation. Should we be looking also to other constitutional documents, look at the Constitution more broadly, to see how this law maybe challenges some of those long-standing principles within the Constitution?
Yeah, I think the arguments will go there, and there will be questions about whether those older instruments you mentioned are themselves applicable constitutional norms with which Bill 21 conflicts. Are those evidence of a sort of unwritten foundational principle of religious freedom? All those things, I think, will be put in front of the judge. Are they still valid federal legislation? In which case, in a conflict between valid federal legislation and provincial legislation, the provincial law kind of ceases to have its effects. So there's lots to discuss there. And then, just to mention, I mean, it's just kind of tragic, but Quebec, the colony of Quebec was actually a kind of leader in the British Empire and the Commonwealth in recognizing religious freedom, as you say, for Catholics, for Jews. So it's kind of tragic that the narrative that's now being told about Quebec is a place that in fact does not respect religious freedom. And so there's a kind of breaking away from Quebec's own past and even the recent past of its Charter of Human Rights and Freedoms, which used to be a kind of source of pride for it. All these things are kind of rupture. And I think the Supreme Court may well be given a very compelling narrative that religious freedom is actually a deeply rooted part of Quebec identity in a way that the current debates aren't showing at all.
I think, for some of our viewers, they might not know that, of course, the civil rights of Catholics were recognized in the Quebec Act in 1774, some 70 plus years before Catholic emancipation in the United Kingdom. So I think to really look at the role that religious freedom, or an understanding of religious freedom, has played in governing the pluralist society that we have in Canada, and certainly in Quebec. Quebec, from its origins, has been a very pluralist, deeply pluralist society. So finally, just a last question. The secular law came up repeatedly in the federal election campaign last year, and Premier Legault and Minister Jean Barrette, who introduced and sort of shepherded the law through the National Assembly, both asserted that the rest of Canada and the federal government had nothing to say to Quebec on this issue. Is this a valid position for the Quebec government to take, and does the rest of Canada have a voice, even to press federal political leaders to take action against the law, maybe in the courts?
I think it's a very tricky argument for Quebec to say that there is no voice outside the level of the provincial government on this issue. I mean, there are fundamental questions about the Canadian Constitution involved, the relationship between the Charter and other parts of the Constitution, other parts of the constitutional framework. And Quebec, certainly, whenever it wishes to, intervenes in litigation going on elsewhere in the country where it thinks it has a stake in the constitutional decision. So Quebec intervened in carbon tax litigation outside the province because it cared how the courts interpreted the Constitution that applies to it. So to say that the federal government or other provinces have no stake in the construal of the Canadian Charter, of the notwithstanding clause, other bits of the Constitution of Canada, doesn't make any sense, and it's inconsistent with how Quebec itself acts. So certainly on the constitutional matters, there's always sensitivity when political judgments made in Quebec are criticized from outside. But on the constitutional matters, in terms of having valid standing to get involved in litigation, to me the path is sort of clear. Of course, other actors affected by the Constitution have a stake.
Well, it's certainly important to remember that not only are these people who are being impacted by this law, not only are they Quebec residents, but they're Canadian citizens, and they have obviously certain rights. Well, Robert Leckey, thank you very much for your insights today. And clearly, this is not the debate is not ended, and we'll be watching closely as new court challenges appear, and we see what arguments are made at that time. So, thanks again very much for joining us.
Good to talk to you. Thank you.